Roland Mumford with Mumford.law. This is the second video in my deposition preparation series. I want to talk about objections. At a deposition, opposing counsel can make an objection on the record. Many attorneys will abuse this and often object to every question. There are generally, in most states, 3 to 4 objections that can be made. One is objection to the form. When a defense attorney objects to the form, what they're saying is that there's an issue with the form of the question that I may have asked you as being the deponent. Maybe it is confusing. Maybe it is 2 or 3 questions combined in one, or there is some other issue that it is inartful or not eloquent. Another reason they may object to the form is that that defense attorney has already coached that deponent that if I say objection to the form, hey, take it as a signal that this question is really important that he's asking. It could be a trap. Be very careful and thoughtful about your response. And at times that is something that attorneys do is they try to coach deponents if I'm not paying attention. One of the things that I always look for if you're the deponent is you're staring at opposing counsel, almost like you're looking for a response or when you're not sure what to say. And I'll immediately look back at the opposing counsel also to let him know that I'm looking. I very often catch the defense attorney trying to signal to the deponent, and that is an ethical violation. Number 2 is if an attorney asserts attorney-client privilege. If they say that the deponent is a client or that there is some form of attorney-client privilege, then they're stating that, therefore, the communications between the attorney and the deponent or you, I cannot ask about. The reason that would come up is I literally will ask, what communications have you had with opposing counsel? In employment discrimination cases, very often I will ask people that are no longer employees, and for the most part, that is probative, meaning I can look into it. Some defense attorneys claim otherwise. Third is if there's an area that I can technically ask about, but the defense attorney thinks that I'm just asking about things that are not relevant to the case or not, quote, reasonably calculated to lead to the discovery of admissible evidence, end quote. That is the language about what the threshold is for what information is probative in a deposition or written discovery. What they'll say is, well, you may technically be able to ask that question, but I don't think it's appropriate. And what they're going to say is, I'm going to seek a protective order with the court about that. And then we will have to have a hearing in front of the court about that issue and about whether I'm limited in that subject area. If they do that, I'm going to demand attorney's fees and sanctions because of the attorney's fees and that I now have to go back and take another deposition. So those are the type of objections that can be made in a deposition. Have a great day.